Hi, everyone. Welcome to our second webinar of the 2023 Estate Litigation Series, Navigating Legal Problems During an Elderly or Vulnerable Person's Lifetime. Thank you all for joining us today. We are looking forward to an informative and hopefully stimulating discussion of this important topic. My name is Lily MacLeod. I'm an associate in Fasken's Toronto office in the Litigation and Dispute Resolution Group. I maintain a broad practice advising clients with respect to estate litigation, substitute decision-making, class actions, injunctions, and general civil and commercial litigation. I am joined by my cross-Canada colleagues. Antoine Aylwin is a partner in our Montreal office and also the co-leader of Fasken's Privacy and Cybersecurity Group. His practice focuses on administrative, civil, commercial litigation, and estate law. Jonathan Lancaster, I'm also joined by today. He is a partner in Fasken's Toronto office. His litigation practice is focused on corporate commercial litigation, commercial real estate litigation, lease arbitrations, banking law, product liability, professional negligence, and estate litigation. And finally, I'm joined by Eric Clavier, is a partner from our Vancouver office. He is a trust and estate litigation lawyer, assisting clients with resolving contentious matters related to wills, undue influence and incapacity claims, committeeship applications, unjust enrichment claims, breach of fiduciary duty cases, and passing of accounts. So in terms of our topic today, as our population ages and with mental health concerns rising in both elderly and younger populations, many of us, whether in a personal or professional capacity, will confront legal dilemmas that arise for elderly or vulnerable people. Elder abuse in itself is a major concern. Approximately 1 in 6 elders will be a victim of abuse, and protection of elders, including their well-being, is a priority for all of us. And legislators are alive to these issues, and today we'll discuss new legislative amendments that prioritize the elderly and vulnerable. So today our presenters will discuss 2 important topics that commonly arise. The first is capacity. Oftentimes family members and professionals are faced with the question, does my loved one or my client have the mental capacity to do a particular act? So today our speakers will talk about testamentary capacity, how courts in Quebec and Ontario have defined the test. When does someone have the capacity to make a will, and also the capacity to marry, and how do those 2 tests differ? And we'll end this topic with a discussion on what is known as predatory marriages. What are they? What kind of damages can flow from them, and what steps can be taken to stop them? And the second topic we'll discuss is power of attorneys. So these are critical tools for helping people manage an incapable person's affairs and ensuring their best interests are protected. But often there are disputes that arise when someone takes up that role. And today our speakers will discuss this, including recent case law. So to begin, we can go to the next slide. And the next slide as well would be great. And next slide, please. So Antoine, to begin, can we talk a little bit about Quebec's new legislative regime and some of the impacts of that legislation?
Yeah, thanks, Lily. Hi, everyone. First thing I want to complete on what Lily said regarding the increasing of seniors in Canada. It's the impact of it. It's directly linked with the increase in the occurrence of some medical issues affecting cognition, as well as related disease and disorders such as dementia in varying types and degree, delirium, delusional disorders, Alzheimer's, cognitive disorders, and other conditions involving reduced functioning and capability, which bring us directly to the subject, because this gives rise to more abuse with elders. 2 numbers. The World Health Organization said have under statistic that 1 in 6 elderly person is victim of some form of abuse. According to a study published in the Lancet Global Health, 11.6% of people aged over 60 have experienced financial abuse. So every jurisdiction are trying to put a safe net in order to preserve vulnerable persons. And the Quebec Civil Code was amended a year ago, November 1st, 2022, to implement a new regime. What's this new regime is about is that we moved from a regime that was really hermetic in terms that there was 3 boxes: advisory, tutorship, curatorship. And these were very defined regime for protecting incapacitated adults. Now we're moving to one regime, which is tutorship, but each individual will have a specific regime that will be varying from one to another depending of the assessment made by the social worker and the doctor in order to preserve any autonomy there is to the individual. So every issue, like in the tutorship, the safety and living conditions, the management of assets, the management of property, all of these issues will be looked at, and the tutor will have more or less power depending of the specific situation of the incapacitated adult. So when we modulate the tutorship in each of these decisions, as you can imagine, it takes a little bit more work in advance in order to present the case to a tribunal, because you need to assess what will be the residual power left to the individual, like the right to choose where to live, the right to sign lease, the right to use money for customary purchases, the right to cash a paycheck. So these are all questions that we will evaluate to see if we revoke the power of the individual to do these gestures or not. There's also a question of revising the situation, because some of the cognition disorder that I mentioned would evolve over time. So depending on the situation, the reassessment will be decided by the court. Maximum 5 years for the psychosocial reassessment, but it could be between 1 and 5 years depending on the situation. And this is the legal regime. There's still a possibility to have mandates of protection, but this and these were increased in terms of protection as well. So a lot of changes in Quebec. We're only 1 year in, so it's still early to see the impact of it. But it's important to see that we have a more tailor-made system than there was before. And this moves to the question of capacity. I mentioned the varying disorder. When we have to ask ourselves in terms of capacity, it's often in the case of a will, we have to look at it at the date the will was stated. It seemed very obvious, but sometimes people have the tendency to think about an individual the way they were when they passed away and not the way they were when they did sign the will. Because if you have the capacity when you sign the will, well, in Quebec, you have the right to give your assets to anyone you like. You don't have any specific obligation as we see in European countries. As the capacity evolves over time, it's really important to go back to the time where the will was made. Speaking of the incapacitated person I mentioned earlier, an incapacitated person of full age can make a will. It's just that it has to be confirmed by the court, and the court will look if the circumstances when the will was made allowed for the validity of will. It's like if there was a shift burden of proof that the will was deemed to be invalid unless proven otherwise. However, in the tutorship regime, the tutor itself never has a power to do a will on behalf of a person. When we ask ourselves a question on capacity, the test is pretty straightforward. As we see on the next slide, there's 3 questions we will ask. Is the individual understanding the meaning of the provision he intends to make? Is he capable of measuring the scope of the provision and appreciate the scope of the will that the author signs? In other words, we want the individual to understand what are his assets and what is the impact of the will. Who's losing or who's gaining from getting the will? And it is said very often that making a will, it's one of the gestures that takes the most cognition in all aspects of life. So the threshold might be higher than usual things that we would do in life that does not need that much capacity. In order to cancel a will, you don't need to show that there is total incapacity. You only need to show that the conditions that I've mentioned earlier are not met, so that the individual is not able to make a sound decision, appreciating the scope of the decision he's making. And the fact, although the courts we see often look at the content of the will to try to assess the capacity of the testator, it's not supposed to be a criteria. It's not because the will makes sense. Under objective quote unquote criteria. So he gives to his wife and his kids, so it makes sense. It's not what we should be looking at. It's really the way the person was when it signed the will. And that's not new. If we look on the next slide, in 1944, the Supreme Court of Canada mentioned what a disposing mind and memory is. So it's one person that could have his own initiative and volition can make the essential elements of will making. So it's still the criteria today that we want to be able to show that on a balance of probabilities, the individual that made the will was able to assess what he was doing. And the burden of proof is always on the person that is contesting the will, except if you're in a case of an incapacitated person. As I said, it's shifted. But other than that, it's on the person contesting the will. And that is the issue of capacity, but there's also the issue of undue influence. Which is a second consideration or a second factor on which you can cancel the will. And as we can see on the next slide, this is something that was developed in connection with contract law by the courts to make sure that the consent is free and enlightened. So undue influence may result from someone positive act, silence, or reticence, where someone would influence with unfair comments. Sometimes it involves lies to make someone make their will in a different fashion that they would do otherwise. And it's important to understand that there's a difference between advocating to become the heir of an individual and bad-mouthing other individual in order to change the content of the will. And when we look at the captation issues or undue influence, the testator's age, state of health, and condition at the time he makes the will may have an impact on the degree of resistance he is able to make to the maneuvers focused upon him. And it's very difficult cases of undue influence because they are fact matters. And nobody will come forward and say, I did try to undue influence the person that to make the will. And normally these discussions are made in the absence of others. So it's always presumption of fact that will be used on these issues.
Okay, thank you. So thank you, Antoine. We've heard from Antoine a bit about the factors that courts will consider in Quebec when determining whether someone has capacity to make a will and the time at which capacity is assessed. So, John, can you talk about how testamentary capacity is assessed in Ontario and how the test might be different, if at all?
Let's speak about capacity as it relates to the main property decisions that people make in their life, that is testamentary capacity for doing a will, and then compare that with capacity to get married, because that also has a tremendous impact on property rights. I'm not going to deal with other capacity issues, such as capacity to determine healthcare questions. I'm just going to focus on the property issues. In both cases, that is testamentary capacity and capacity to get married, it's a question of fact, always depends upon the circumstances. Generally, although the tests are different, the court is looking at whether somebody can make an autonomous decision. And courts protect the autonomy of an individual in that capacity is presumed. And that becomes difficult when you're dealing with the elder and the vulnerable cases, because there's still a presumption of capacity. As it says on the screen here, it's a decision that the court looks at. What's the decision being made? What's the time frame? And what's the specific situation? And it can change, as can people's capacity change. It can fluctuate over time as well. We'll look at one of those cases in a moment. So turning to the next slide, testamentary capacity in Ontario. There's a three-part test. You have to understand, obviously, what making a will is about as a final disposition of your assets. You have to understand the nature and extent of your assets, and you have to appreciate who may have natural claims. You don't have to include them in your will, subject to certain statutory obligations to take care of dependents. But other than that, you can give your property to whomever you wish, but the court does like to have seen someone think, well, who would have a natural interest in the estate? Typically, it's children. If there's no children, it could be parents, it could be siblings. That's what the court will look at. Sometimes you'll see a will drafted. If they don't wish to leave property to children, particularly adult children, the will may say, I've turned my mind to whether I should leave anything to my children or a child, and I've decided no, and here are the circumstances. It could be in a I suppose, a document prepared at the same time as the will, but sometimes you do see it in the will, and that's really to show capacity. It also prevents a challenge to the will. So those are the three tests for making a will. They can be relatively rigorous relative to the capacity to marry, which is a much, much lower threshold. I think the next slide we have is actually Quebec, so we'll maybe bounce it back to Antoine.
Right. So I think we're going to look at some recent cases in both Quebec and Ontario next, just sort of applying the test. So is there anything notable about how the courts have applied the test in most recent years, or any new emerging trends in the case law that we've noticed?
Yeah, it's interesting to look at the recent cases. I'll mention two to see how the courts are dealing with these issues. In the Russi case, a decision of 2023, the late Russi was widowed in 1993 of her husband, the father of her two children. In 2002, she remarried with a defendant who's 20 years her junior, so probably the age of her children. That's a good fact pattern for litigation usually. And she's making a first will where she buys a specific property. In the will, she bequeathed this property in particular to her new husband. And in 2012, a few months after suffering a stroke, she makes a new will where she bequeathed all of her property to her new husband. As you can imagine, the kids are not particularly pleased with it. And they challenge the will on the base of capacity. The court looks at the matter to see if she was able to appreciate the scope and consequences of the will, as I mentioned earlier. And the debate or the discussion is really about the medical condition of Mrs. Russi when she made her will, and particularly the impact of her stroke. And there was an expert that mentioned that she was, and don't ask me what it is, but she was suffering from anosognosia and severe aphasia. And the consequences of it, according to the expert, is that she would not have been able to express her wish to change her will. And since she had never mentioned before her stroke that she was intending to make her will, the court came to the conclusion that it was unlikely that she had the will to change her bequest the way it did, and that she was not able to formulate her intention at the time of signing of the will, given her state of wealth. This with other elements of fact where mentions of contradictions in the new husband testimony came to the conclusion that the will had to be set aside. The other cases I wanted to mention, another cases of 2023, where I'm giving you the punch of the story at the outset. The will was not set aside in this case, in the case of Gagnon. It was the case of a deceased who died at the age of 93. And we were looking at the 3 wills that were made. The first will, he's providing a specific bequest to one of his sons, Claude. The second will is removing the bequest to Claude, and the third will is bringing back the specific bequest to Claude. And the other son is contesting the will, and he's bringing forward the father's Alzheimer's disease, stage 5, at the time of the will as being a reason to set aside the will based on capacity. The court reminds everyone that since 2004, it's well established in Quebec how the burden of proof works. The person contesting the will has to demonstrate a general incapacity at the time of the will. Then this shifts the burden to the person defending the will to demonstrate that at the exact timing of the will, there was an interval of lucidity that would demonstrate that even if there would be general incapacity at the time, the will still be preserved. And the court reminds also that age and illness are not sufficient to establish incapacity. So it's not because you're old that we can establish a conclusion that you're incapacitated. We have to go through the test of capacity. There's also a discussion about the role of notaries. In Quebec, most of the will are drawn up by notaries. And the role of the notary is not one to attest the capacity of someone. Their only obligation is if they feel that someone does not understand what they are doing, they should refuse to take the will. But they're not health specialists in order to assess capacity. So even if the decedent had Alzheimer at stage 5, the proof demonstrate that he knew what he was doing at the time, that he had expressed his understanding of his will to the notary, that he understood the impact of the change he was making in the will, and therefore the proof demonstrated that he even argued the reasons why he was doing the change with the notary. So even if he had some transient episodes of confusion, he was not in a state at the time of the will where the will had to be set aside because of his capacity. So, every time you'll come to a lawyer in a will matter, we will tell you the facts are really important. And that's another example where you see that the court, even with someone that's Alzheimer's stage 5, had a fact pattern where they come to conclusion that the will was valid.
Great, thank you. And John, the Court of Appeal and Ontario Court of Appeals commented on the test and applied it in the last few years. So do you want to tell us about those cases?
Yeah, I'm just really going to talk about the McGrath case because it has the most startling facts. The Nunzio case and the Leonard case really just apply the McGrath case. In the McGrath case, the Ontario Court of Appeal took the opportunity to make a list of 3 factors into 5. They're really no different than the 3 factors we listed above. They've just broken them up a little bit. So factor number 1 is the same: understand the nature and effect of the will, and then recollect the nature and extent of the testator's property. That was really all part of one test under the previous case. 3 is understand the extent of what he or she is giving under the will. That's the property. And then 4 and 5 are really combined into one test. This is remember the people that you might be expected to benefit, typically family, and the nature and extent of claims that may be persons that are being excluded. This typically involves dependents. If you're not going to leave assets for a dependent, the will should demonstrate that. There is statutory relief against that by the dependent, but the court still has regard to the testator's wishes and the autonomy of the testator, provided that at least something sufficient is left. The facts of the McGrath case are startling because the will in this case was a holograph will. And for those who don't know, that just means it's in the testator's own handwriting, signed by the testator at the end, obviously dated. It doesn't require a witness. In this particular case, the holograph, what was found to be a holograph will, was contained within a suicide note. And so that raised, and the evidence was that the testator had been taking drugs and drinking on the day before. They had killed themselves. I think it might have been Christmas Day they killed themselves. It's a very unfortunate set of circumstances, but the Court of Appeal determined that simply the fact that the person had a drug addiction, an alcohol addiction, did not undermine capacity. That was a separate test, and set aside the trial judge, but did determine that the individual had the capacity at the requisite time, that is when they were drafting the suicide note, and that the suicide note contained enough information in it that the court could say who was going to get the property. So the court applied this 5-part test here on testamentary capacity in the context of, as I say, rather extraordinary set of facts. But it's the same test across the board, and that, again, that's a holographic will that's contained within a suicide note.
Okay, thank you for that. So I guess switching gears a bit to talk about the capacity to marry. So John, can you tell us about how that test is different from testamentary capacity and what factors the courts have emphasized in applying this test, or what's interesting about the recent case law?
Yeah, so this is a much, much lower threshold, and many people who could have the capacity to marry may not have the capacity to create a will. It really involves the autonomy to make a decision regarding marriage, understand the nature of a marriage, but it's not a very high threshold. Interestingly, under the Marriage Act, it provides that no person shall issue a license to or solemnize the marriage of any person who, based on what he or she knows, has reasonable grounds to believe that the person lacks the capacity to marry by reason of being under the influence of intoxicating liquor or drugs, or for any other reason. Now, practically speaking, when people go to City Hall, you're probably not going to get too much of a rigorous review there. But my understanding is both people have to be there, and so that at least there can be a once over. But I wouldn't put too much comfort in that government protection. The same applies to the wedding official as well, of course. So I guess that'll tell you to have the party after the ceremony and not before. There is that check. There's an interesting question of, at what point in time do you assess the capacity? Is it at the time of the proposal for marriage, what used to be known as the wedding contract? Is it at the time of the obtaining of the license? Is it at the time of the ceremony? Typically, you see these cases attacked at the time of the ceremony, so that's really what the court focuses on. And that's ultimately the key time that you have to have the capacity, is at the time of the ceremony. the time of engagement has become less meaningful in law. It used to be there was a claim that you could make against someone for breach of the engagement promise. And that if somebody didn't go through with the marriage, there was a claim in Ontario up until 1978, you could sue them for a breach of that promise. That's long gone. So that's not really the relevant time anymore. Really, it does focus on at or about the time of the wedding ceremony. Of course, you can refer to some events before because they give context to the capacity at the time that the marriage occurs. We're just going to go to the next slide. This is a relatively recent case where it was found that the prospective husband, in this case, Mr. Hunt, did not have the capacity to marry. He'd been injured quite badly in an accident, as you can see, leading to a brain injury. And this was, of course, Mr. Hunt was not bringing the action. It was a litigation guardian appointed for him. And Mr. Hunt's family were most unhappy with this wedding. So they came forward with the evidence as to what his real state of affairs were at the time. I think this was up in around Parry Sound. And you'll see on the screen here, the test for capacity requires that persons entering into a marriage contract understand the duties and responsibilities which a marriage creates and have the ability to manage themselves and their affairs. So it's a fairly low standard, as you can see, but in this particular case, the facts were egregious. The court agreed and determined that the marriage was void. And in law, there's a difference between void and voidable. Void means it just didn't happen. That marriage didn't happen at all. There are other circumstances we'll look at later on that can create a voidable marriage, but if there's no capacity, there's no contract of marriage. This particular case focused on the time the decision was made. That is the time of the ceremony. There are other recent cases over on the next slide. There's the Tanti case. Again, this is a decision where there was a concern about the capacity to get married. This was an elderly person, a younger living companion, but the court found in this case there was a requisite capacity. Same test, always different facts. You'll never find the facts are the same. But in this particular case, because of the nature of the relationship between the two of them, the history of that relationship, but they lived together before for a period of time, the court found that there was capacity in this case. All these cases are difficult. One of the things that you see in the cases in the litigation is an attempt to get information from third-party witnesses, because often the family members have a vested interest because they're concerned about, and naturally concerned and lovingly concerned about their parents' property being frittered or taken away or wasted. But they also are the ones who suffer, whereas if it's neighbors or whatever who witness it, who don't really have a stake in it, their evidence tends to be more credible, more balanced. So that's what you see in a lot of these cases. There's another decision on the next slide, the Eves case. Same outcome. It was upheld because there was capacity that had been demonstrated, but you'll see in this case the reference to getting information from lay witnesses who are not bound up in it. If you are concerned yourselves about these situations, then you can start memorializing what's going on, whether it's by way of picking up your phone and filming things, recording a conversation, making observations of what the person who you feel is being taken advantage of, what they're saying and doing. The next situation deals with really what is the concern these days, predatory marriages. They're no different test. Is their capacity, although there are some other issues we'll look at, like undue influence that Antoine had mentioned earlier in terms of Quebec. An effort arguably has been made by the legislature to deal with these by changing the law on whether or not a marriage revokes an existing will. The law used to be that it does, They flipped that over now since the beginning of 2022. A marriage does not revoke a will. And so the person getting married would have to go through the process of revoking the will, and there's a test for that. There is a suggestion in the cases, or some articles that talk about the cases, that the test for revocation of a will is the same as the test for entry into a will. I'm not so sure that's the case. The cases they've alluded to that, but the ones I've seen haven't actually made a final determination on that. But that is a way of attempting to preserve the existing property rights unless you get over a certain hurdle, that is, have the capacity to revoke a will. And the obvious protection there is that there's a low capacity to get married, but if you want to change your existing property rights, then you have to revoke the will. And even if you don't have the capacity to enter into a new will, then your assets will go out in accordance with the what are known as the intestacy rules, which is the statutory regime where someone doesn't leave a will at all, or their will only deals with a part of their property, or it doesn't deal with all of the interests to the very end. If you leave something to somebody for life, you need to say who gets it after the lifetime of that person. Over on the next slide, I've mentioned this a couple of times. A marriage can be voidable if consent to the marriage was procured by undue influence, duress, coercion, or unconscionability. And this is really what you're probably going to see more in the cases rather than just a basic capacity test, because that is such a low threshold. And this is really where you do need to start gathering evidence of the circumstances and the situation that the person getting married is put in. And again, all these cases are individual facts. Now, these marriages are voidable. They're not, somebody would have to bring a claim on behalf of the married person to have the court determine that there was undue influence, duress, coercion, etc., and ask the court to set aside the marriage on that basis. Interestingly, however, in Ontario, the Family Law Act provides that even though a marriage is void or voidable, that does not necessarily do away with the obligations under the Family Law Act to provide for property rights, although it's certainly a factor. And there are cases where there was an unconscionable marriage and the court denied the person the claim under the Family Law Act, seeking to nonetheless to get the spousal rights under the Family Law Act. The next slide is really what can be done, and this is particularly the case with elderly parents, to protect the assets during that person's lifetime. Joint accounts are often used. There may be an adult child. We've said they're not foolproof because either one of the joint owners can walk into the bank and sever the account, get rid of the joint account. And they can be brought there under the influence of the person that you're seeking to protect the assets from. So they do provide some protection, but often they also lead to fights between the adult children if only one is on the account. So there's another host of problems that go along with that. There are powers of attorney for property that can be entered into. They're helpful. They give you the ability to take those assets and try to protect them if you see the situation coming. On the other hand, a power of attorney can be revoked. And they just have to have the capacity to revoke the power of attorney. There can be a contest about that. Guardianship orders are pretty much foolproof. They're an order of the court that someone else is solely managing the property of the person with the issues. These can be expensive orders to obtain because you've got to have an assessment done for the individual, a capacity assessment, satisfy the court that there is a lack of capacity, ability to deal with property. That's a fairly rigorous standard. And you also have to prepare a management plan for the court to approve as to how that property is going to be managed. But when you do get the order, you're the sole person who can deal with the property from that point. Finally, another way to get protection here, at least in real estate transactions, is that there is an application process under the Land Titles Act where there can be a registration put on title to try to protect property of vulnerable persons if the registrar is satisfied as the incapacity of the individual in issue. So those are a number of ways to protect it. Of course, as I mentioned, the other way is gather evidence, and not only through family members, but through objective third parties as well. And I think, there's one last thing. There's some considerations. These are just factors here on the slide about what you look at. Well, we've got to give Eric some time here, so I'm going to move on to the next slide. Very briefly, there are considerations for lawyers in the rules of professional conduct. A lawyer has to be on the lookout for vulnerable people who are being taken advantage of, and the Law Society in every week there's a release of a number of cases called the Ontario Reports, and the Law Society puts notices in it. And for the last couple of months, the Law Society has been putting notices in there that lawyers are required to be on the lookout for exploitive loan agreements. These are where people go to homes, typically of people with diminished capacity, and sell a new roofing or what have you. And before you know it, the person's entered into a mortgage on their home because they don't really know what they're signing. And obviously, if they're going to try to claim some sort of interest in the home, that typically has to go through a lawyer because there has to be a registration. So lawyers are required and put on notice now by the Law Society to be on the lookout for these arrangements, again, in an effort to try to protect vulnerable persons.
Thanks, John. So as John has mentioned, a power of attorney can be a helpful tool in circumstances where an elderly person is in a predatory relationship, for example, but often power of attorney can give rise to problems and disputes, sometimes related to capacity. Did the person have capacity to make a power of attorney, or concerns about how the attorney is performing their role? So each of the provinces have different pieces of legislation. Eric, can you tell us at a high level what is a power of attorney and what attorneys can do generally?
Yes, thank you, Lily. I will do that. And good morning from Vancouver. It's still morning here, so that's why I greet you that way. I'm going to do a very high-level overview of what a power of attorney is and the two types of substitute decision-maker documents that can help an elderly person that they can make. And the most important consideration is we've heard about capacity. These documents can largely only be made when the person still has full capacity, although when it comes to the BC legislation on a representation agreement, some diminished capacity does still allow for the person who I shall call the donor to make a representation agreement. So on a high level, what is a POA? It's a document in which you appoint somebody else to make decisions on your behalf. And there are generally two types of powers of attorney. In British Columbia, we've actually got two separate pieces of legislation that govern those two documents. The first is the power of attorney under the Power of Attorney Act. That relates to financial affairs, business, property, legal, that kind of thing. So you're giving someone authority to deal with those issues on your behalf. And then the second is a representation agreement under the act of the same name, in terms of which you're giving someone authority to make your personal healthcare decisions. And then that again is broken down into two types of representation agreements, at least within BC. You've got a Section 7 agreement and you've got a Section 9 agreement. The Section 7 agreement is the one that allows for personal healthcare decisions to be taken, as well as some routine financial affairs. That would be paying bills and, banking checks, that kind of thing. The Section 9 representation agreement gives some very broad powers, including end-of-life decision-making, as well as the personal care and healthcare decision-making. And we don't have the time to get into it, but those tests for capacity as to what the person making the RA is capable of doing and appreciating, they differ for the Section 7 and Section 9 rep agreements. So over to the next slide. The next question you have to ask yourself is who in fact can make a power of attorney or a representation agreement. With the power of attorney and the representation agreement, we're talking within the context of today's presentation about individuals, but you can know that a corporation can make a power of attorney as well. The threshold requirement is, of course, capacity, but you need to have an adult dealing with their affairs or their representation agreement and healthcare decision making. So in BC, that means you've got to be 19 years or older. And then there is the test that the two different pieces of legislation prescribe under Section 12 of the Power of Attorney Act and Section 8 and 10, or Sections 8 and 10 of the Representation Agreement Act as far as capacity is concerned. But I don't want to belabor the point because you've heard about it, but the question that needs to be answered is, does the donor understand that the attorney might misuse the attorney's authority? And that's one of the most important considerations, because of course you're giving such an important and such a powerful document to another person. But I've just singled that one out because it's important in the context of elder abuse and the kinds of advantages that some family members might take of the person. So when we as lawyers look at preparing a power of attorney, we need to ensure that that person knows that they are giving a very powerful set of authorities to the attorney and that could be abused. So there are two types of powers of attorney in British Columbia. The first is the non-enduring power of attorney, and the second is the enduring power of attorney. A non-enduring power of attorney is your garden variety power of attorney. It really just allows somebody else to make decisions on your behalf, but it terminates upon you losing capacity. So it does not allow the person who you appoint as attorney to act on your behalf with regards to business and financial affairs if you were to lose capacity. Contrast that with an enduring power of attorney, which contains a specific clause in it that says that this power of attorney shall prevail, shall be valid once I lose capacity. And that is really the one that you're looking at in the context of helping elderly people, because the whole point is to have somebody available to provide them with assistance and to do their financial management once they lose capacity. So the enduring portion of it is super important, but that one terminates upon the death of the donor. So when the adult dies, the enduring power of attorney is immediately invalid. I've mentioned the death of the donor. That's one of the grounds upon which a power of attorney may terminate, but there are several others. You can, as the donor, provided you still have capacity, and it's the same capacity you would need to make the power of attorney, you can revoke the power of attorney, and provided you give notice to the attorney, that terminates the power of attorney. The suspension of powers is something else that you retain for yourself. Once again, provided that you retain capacity, you can suspend the powers you've given to a power of attorney, again, on written notice to that attorney. And then whilst that suspension is in place, the power of attorney cannot be used. There's the donor's death and the committeeship that might arise where there is an issue relating to the power of attorney, and I'll get to that shortly, but committeeship is the British Columbia name that we give to guardianship. There are some criminal offenses by an attorney that would disqualify them from continuing to act. And then, of course, if the attorney were to die, become incapable himself or herself, or be bankrupt, then they would not be entitled to act as attorney anymore. So it is important to know, I've mentioned how powerful this document is, but it's important to know that whilst the donor is capable, you as the attorney or the attorney would be acting as an agent for the donor, which means that the donor, like I say, can revoke the power of attorney, but the agent would be liable to report to the donor. After the donor's loss of capacity, the attorney becomes a fiduciary, which instills a whole new set of responsibilities on the attorney because they're now acting in a fiduciary role and they will be held to a higher standard. And so because the donor is no longer capable, him or herself, the attorney would have to report to the estate of the donor when they eventually pass, or somebody that steps into the shoes of the donor if there is a dispute. And I'll get to some of the remedies that are available. But the most important thing to know is that when you're an attorney, you're supposed to put the best interests of the donor first and foremost. You cannot act in your own best interests. You cannot self-deal. If you do, you're in breach of the Power of Attorney Act. You're likely to be removed or to be found to have breached that act, that power of attorney, and all kinds of consequences could arise. The exception to that is if the power of attorney itself does in fact allow for self-dealing. But generally speaking, that is a very rare clause. And the whole reason is that the power of attorney is supposed to act for the best interests or in the best interests of the donor. A very important consideration, and I believe you've heard it early on, but I'll just stress this, in BC as well, the power of attorney does not allow an attorney under any circumstances to make a will for the donor, although there are some limited estate planning measures that can be done. But the power of attorney really should not be seen as a substitute that you give an attorney in order for them to do your estate plan. It's one of the tools that we use in an estate plan. And generally speaking, that would be a will, power of attorney, or a rep agreement, but there can be different ones. But just know there can be no will made on behalf of the donor by the attorney. So then the topic that I'm covering is disputes, and I've given you some high-level sort of overview of what the power of attorney is, but what can go wrong? And let's start with the obvious fact, which is that it's an immensely powerful document in terms of which, unless you limit its powers as the donor, the attorney can essentially do anything that you could do with your property and with your bank accounts and any other financial matters that you have, shares in companies and whatnot. The power of attorney is an extremely important and extremely powerful document. And so when you pick an attorney, you have to pick the right attorney. You have to trust them unconditionally. And if you're even remotely concerned about the person that you're appointing, appoint somebody else. And so the reason we mention this is because an attorney can go wrong in many different ways. Disputes can arise in many different ways. And one of the most obvious ones is, of course, that the attorney will do something outside the scope of the POA or at law. So I mentioned you're not allowed to self-deal. Let's say the person enters into a transaction whereby they buy the property of the donor and they purchase it themselves or in an affiliated company or something akin to a non-arm's length transaction. That would be a breach of the power of attorney. That would immediately give rise to a dispute. Oftentimes, and we see this unfortunately on the rise, a power of attorney is used to empty a donor's bank accounts, and the attorney makes off with the funds in that bank account, leaving the elderly person destitute or not able to access the funds that they've built a lifetime accumulating. So that would be a big problem, obviously. The breach of a fiduciary duty after the incapacity is broader, but I mean, it always circles back to, is the attorney acting in the best interests of the donor, or are they acting either in their own self-interest or in a way which does not further the best interests of the donor? And that can lead to disputes. Oftentimes, funds in bank accounts are used to buy a motor vehicle, for example. There is a dispute about whether or not that motor vehicle is really necessary, and family members will get into deadlock and will get into disputes about these kinds of breaches. You also, when you pick an attorney, can pick more than one. You can have two or you can have four, but that's not a good idea unless you have some kind of a deadlock provision which allows a majority to vote, because very often you will have two attorneys who see things differently and they end up in a deadlock. That deadlock can only be resolved by either one of them stepping down or alternatively going to court and getting a committeeship order, which I will get to shortly. And then, of course, the important thing, as I mentioned, you have to account to the donor while they're capable. A failure to account to a donor is a dispute that could give rise to a removal or a suspension or a cancellation of that power of attorney. But far more often, the failure to account happens when the donor has lost capacity. And then there is really nobody that can force the attorney to account. So during that period of incapacity, unless a committee is appointed, the donor is essentially at the whims of the fiduciary who is now failing to account, and nobody can really look that over. And that's why sometimes a committeeship is necessary. I'm not going to deal at length with the power of attorney having been obtained under suspicious circumstances, because that was touched upon. But that would be, for example, if there's a fear on the parts of family members that there was undue influence that was used to get the power of attorney done, or that there was a lack of capacity at the time that the adult made the power of attorney. So those are just some of the disputes. So next up, we'll then look at, well, what are the remedies or the options if the attorney is misbehaving? In BC, one of the first steps you can take is contact the public guardian and trustee, who would then investigate. You can seek relief under the Power of Attorney Act itself, which would be seeking to restrict the attorney's powers, for example. You can make a civil claim against the attorney if you are the adult and you still have capacity, or if the estate later wants to make a claim against the attorney. You can seek injunctive relief. And then there is a section in the criminal code which allows for some relief as well. But the most important tool in the toolbox for somebody who challenges what the attorney is doing is a committeeship or a guardianship order. And I will get to that shortly. But if we can go to the next slide, you'll see that the PGT really will, in all cases, review the report. They'll investigate it. They can then either apply to court for relief. They can take steps to become the guardian or the committee for the adult themselves. They can take actions that they think are necessary, or very often they take no action and they leave it to the family to resolve. And so that's then when we get to the committeeship. And so if we move on to the next slide, you will see that I've set out here that the Patients Property Act is what governs a committeeship or a guardianship order in BC. In order to obtain a guardianship order in BC, you need affidavits from 2 medical practitioners who declare that this patient, the adult in the case that has lost capacity, is no longer capable of managing their affairs and or their person. So there's 2 types of committees or committeeships that can be ordered: a person or a committeeship of estate, or you can have both. This is the way that you terminate a power of attorney or a representation agreement if the person has lost capacity and is unable to do so themselves. You have to go to court. You need these 2 threshold affidavits in order to get the court to consider their application. But the problem that you have sometimes is that the person who is the attorney or the rep might be isolating mom or dad. You're not able to get an affidavit from a medical practitioner. You're not getting cooperation from medical practitioners. So this is really the big dispute that you're going to be facing. It's all well and good if there is no issue between siblings as to who should be the committee for mom or dad. The problem really arises when there are conflicting camps. And recently, I was involved in a matter here in BC where there were 4 powers of attorney appointed. Each one had the same powers. They were in a deadlock because there were 2 camps. The only solution to that deadlock was to apply for a committeeship. And so we went to court. After 4 days at $120,000 on each side, the court ruled that one of the children was going to be the committee. So that's just one of the problems that you can have. Another problem is, even if you apply to court for a committeeship, there could be a nomination of committee that the adult made whilst they were still capable. And the court is bound to follow that unless good reason exists not to do so. The test, though, ultimately, in whether or not to appoint a committee to act on behalf of the adult who had made a power of attorney or a representation agreement, which is now no longer valid, it's automatically terminated by the committeeship order. The ultimate test and consideration that the court looks at is what is in the interests of the patient.
Antoine, can you speak a little bit about the process for removing powers of attorney or tutors and mandatories in Quebec and what that requires?
Yeah, well, for both, it's the same question. Are either a tutor or mandatory, they could be replaced if they're unable to perform the duties or neglects its obligation. The reason must be serious. So it is possible. The court will want, since it has a wide discretion, to make sure that the reasons given are not benign, but really serious. The only difference between a tutor and mandatory is the tutor was appointed by the court. The mandatory was chosen by the incapacitated person. So the court will have more reluctance to replace a mandatory that the incapacitated person chose than to replace a tutor that she chose, that the court chosen herself. And that's what we see on the next slide. To the idea to give precedence to the will expressed by the mandator. The burden of replacement of a mandatory, as we can see on the next slide, relies on the person who asked for it. Failing convincing proof, the statu quo will prevail and the replacement will not be ordered. The impression, the satisfactions as general allegations would not be sufficient. In a recent case of 2023 GD against DS, the allegations were really important because it was alleged that there was a conflict of interest, family conflict, behavior constituting economic violence towards the individual concerned. But that at the end of the day, when the court heard everybody testifying, it came to the conclusion that the evidence only showed that people would not understand what the role of the mandatory was. And that there was no evidence that the incapacitated person suffered any damages from the management. So at the end of the day, it's the well-being of the person that is at stake, and that's what the court will check. Last comment I would make is the number of mandatory. When you do a mandate, you may choose more than one mandatory, either to split the work or to work as a committee. So you could split the work, for example, one person that deals with the person, so health decision, for example, the other person dealing with property. If you're dealing as a committee, we do recommend that you make specific rules for making decision as a majority. Otherwise, it's going to be unanimously decision, and that could be complicated. One thing you have to keep in mind: when you move towards a committee, the rise of conflicts is more often than when you have only one person acting for taking the decisions. And that's pretty much what you have to keep in mind when you make your decision. So I'm going to skip this one, given that we're at the Q&A session, and coming back to you, Lily.
Great. Well, thank you all for a terrific discussion. In terms of questions, we just have a quick question about the amendment to the Succession Law Reform Act, John. Our audience just wants to confirm that marriages after Jan 1, 2022 do not automatically revoke the testator's will.
That is correct. Yeah, that changes the old legislation, which had actually, the old legislation reflected the common law rule, but that's now gone. It does give some protection. On the other hand, at the same time, the government also reduced the number of formalities that were required for a will. So while they've made it, there's not a revocation anymore, it's some of the, I'm not talking about capacity, I'm just talking about the formalities of a will, two witnesses, et cetera. They've made it somewhat easier in that respect as well.
Excellent. Thank you for that. And we had some questions that were submitted in advance. Someone asked about the key concerns for an attorney acting under a power of attorney who's dealing with parents in senior residences. Could Eric, perhaps you speak about some of the concerns they might encounter?
Sure. And so just to clarify, in BC, we would be talking about the representation agreement that I discussed, but I think that the same concerns would be applicable. One of the big issues when you're dealing with a care home or, on behalf of your parent is you, of course, want to make sure that they are properly looked after, that the care home is properly following your instructions, that they're not being harassed by other family members who might be wanting to come and influence them to maybe change a will or give a gift or something. And so you want to be careful and mindful of the fact that as much as you want to have those family members be able to visit their parent, you want to be sure that they do not do so in order to put stress or try and exert some kind of influence on the parent. Another issue you may have is that you might not be getting anywhere with the care home, or that there is interference from other family members. It can make it very uncomfortable for the persons that work at the care home, for the staff there, And that can often make it difficult also for the parent. I can use an example of the power of attorney dispute that I mentioned earlier on, where there were the two different camps. And whilst mom was in the care home, they were doing different things to try and get her out. The one side was, the other side was trying to keep her there because they thought it was in her best interest. And it really put the care home in a difficult position. So I think when you are the representation agreement holder and acting on behalf of an elderly person with a care facility, you have to be mindful of all of the players, all of the roles that you're essentially trying to navigate, and to make sure that you keep the peace in amongst family members, the care facility, and of course, keep the well-being of the adult that you're acting for at the front and center of any decision that you make.
That's very helpful. John, Antoine, please feel free to add any additional comments as it relates to Ontario, if you have any, or Quebec.
I wouldn't say there are additional concerns in Ontario. Most of these cases don't really turn on the nature of the underlying document, that is the power of attorney document. It's the family or whoever's, and it's the facts that are presented. You can obviously give a copy of the power of attorney, whether it's for property or for healthcare, to the seniors' home, so they know who's legally calling the shots. But as I say, they really do turn on the facts. And frankly, whether in a senior's home or somewhere else, living with someone else or living somewhere else, you're going to see the same set of facts. They just unfold that way.
Yeah.
And if I can just, I'm sorry, Antoine, go ahead.
Thank you. I just want to add one thing. When these kind of situation occurs where one family is trying to pull in a direction, one part of the family is pulling in the other, I think it's time to document the situation and to leave traces of what has been done, when and how, in order to protect yourself in the future when there's going to be potentially a litigation on the power of attorney or for the will thereafter. It takes... we look at the recent history often of what happened, and that's a very good idea to keep track of everything that was done in that crucial period of time.
Yeah, I would agree with that. I think that's great advice. And what I would add is that when it comes to dealing with an old age home or care facility, they generally accept, unless there's an issue to question, the representation agreement, or in other provinces, the power of attorney for that person's personal decision making. But when it comes to end of life decisions, when the person is in hospital, as much as the representation agreement is the document that authorizes the holder to make those decisions, my experiences, and I've heard it from physicians, is that they do try and involve other family members, even though there is this document that says, I want to have person A make these decisions on my behalf. The hospitals don't consider themselves bound by this. They really look at what is it that the family wants to do, and can that be discussed? And they do it by committee, informally anyway, even though there's this person that has the document. So I think it's important to know that even though you appoint someone to be your representative, that doesn't mean that that person alone is going to make the decisions when an end-of-life decision has to be taken.
Terrific. Thank you. Another question someone asked, when can an individual's power of attorney for property be invoked so that the parties assigned to take over responsibility for that individual can act? And what are the medical conditions, if any, that have to be present for that to be invoked?
Okay, so maybe I can answer that because I spoke about the powers of attorney. I mean, a general power of attorney or an enduring power of attorney is valid and effective from the moment it is made, unless it is what we call a springing power of attorney, which requires some kind of a triggering event to take place that would then cause the power of attorney to take effect. In practice, you might make a power of attorney when you're fully capable, and it doesn't get utilized or used by your attorney or attorneys until you actually lose capacity, because it's not necessary for them to act on your behalf. But generally, it's valid from the moment it is signed. A springing power of attorney, on the other hand, you would have some kind of a triggering event that you say, and in this case, most likely that you lose capacity, at which time that power of attorney becomes effective and can be used. The difficulty is in how do you prove a lack of capacity? Who's going to make that determination? And how do you know that the triggering mechanism has in fact been triggered? right? And so we generally don't recommend that you use a springing power of attorney because it is such a difficult road to travel to try and determine, because it could be, for example, that once a doctor declares that you're incapable, that's a springing power of attorney. But what if there's a dispute about that doctor's opinion? Then what happens? Do you end up going the committeeship route, or do other family members? And if you have any concerns at all about the power of attorney taking effect right away, you've picked the wrong attorney. You got to pick the right attorney that you trust will not take over until such time as you lose capacity, because all you need to do is ask them not to do anything until they think you're no longer capable.
And it's interesting because Quebec chose to have a different route on this issue. Powers of attorney are valid until incapacity occurs. And the mandates in terms of incapacity only springs when incapacity is recognized by the court, leaving in the same way, however, a gray zone when a person is in the realm of incapacity but not recognized by court yet. So that's where you have to be very prudent when you're in that zone in order to make sure that you're not doing any important decisions, because then they could be challenged.
It's the same as Eric's described it in BC.
Good. We have time for one more. So I will mention, somebody said they wanted to know about how to deal with situations where an individual's behavior is debilitating for caregivers, but the person is able to present as capable and denies the behavior when assessed. So perhaps one of you could speak about sort of the considerations that might be relevant, questions that you might ask in those situations, including, what kind of capacity the person is dealing with, perhaps.
And particularly if there's a dispute about it, you're going to have the capacity assessment done of the person. An experienced capacity assessor should be able to determine whether there's a facade here or whether there is a real lack of capacity. Not a lot an individual can do. It can document it, as Antoine has said, in a different context, but you can always document it. But at the end of the day, if there's a dispute coming, you should get an assessment done.
And I would add to that sometimes we may end up litigating the assessment itself, because in the case that you just mentioned, maybe the individual does not want to submit to an assessment. And then you have to ask the court to render an order. These are probably the messier cases that are the more complicated to deal with, because the caretaker in the meantime are in a very difficult situation to deal with this individual, and especially in the fact pattern that you described, you want to move quickly in these situations.
Yeah, and I would just say this, is that one has to remember that capacity is a legal test. It's not a medical test. So whilst a medical assessment of the adult is, of course, important and is one of the factors that the court will look at, the court will also look at the evidence of collateral witnesses as to whether or not this person, in fact, has a lack of capacity. But it's exactly right, is that if the adult doesn't want to submit to a capacity assessment, it's very difficult to have them assessed, because you can't assume that because the person doesn't want to submit to a capacity assessment that they therefore lack capacity. And at law in BC, and I believe that's the same in most of the common law provinces, a person is presumed to be capable, right, as an adult. And so it's not a question of, well, I can just get him assessed by someone. It can be very messy. I want to borrow that word, because the only way to then do it is to approach the court for an order compelling that adult to submit themselves to a capacity assessment. And once that capacity assessment shows that they are lacking capacity, you would need a second one to get a committeeship in BC. But it's not something you really want to put your parents through. And it's very tricky. So you always have to remember that there are so many issues that can arise, and that if you have any concerns or questions at all, seek legal advice first before you do anything.
Thank you, Eric. And thank you to all of you for being here today, all the information and knowledge you've shared with us. Thank you to the audience for joining us today. It's great to be with you virtually, although I cannot see you. Just a reminder to please fill in the survey if you have not done so already. Give us feedback, any topics you'd like to see covered in the future. And our last webinar in this 2023 estate planning webinar series is being held on December 7th. And that one will focus on disputes involving the administration of a will or a trust. If you'd like to register or watch any of the past webinars, please visit the Fasken Institute section of fasken.com. And otherwise, have a great afternoon. We look forward to seeing you.